Here is how we'll do it. 1 is a clap. 2 is a snap. And 3 is a snap. Okay? 1, 2, 3. 1, 2, and 1, 2, 3. 1, 2, 3. Nice. Now pair up. In pairs. Who will be my other? Come on. Higher in pairs. I'm good. Listen, now here are the instructions. I do 1, you do 2, I do 3, you do 1, okay? And it goes on like that. Example. 1, no. What is 2? And 3? So 1, 3, 1. No, alternate. Who has got the game? I do it with them. Higher. 1. Higher. Listen. Just watch me and him. First watch me and him. I'm going to drop the mic for a minute. Just watch. We are alternating. So, 1, 2. What is 2? Higher. 1, 3. No! Petition for another volunteer. So, instructions. So the instructions are 1 is a clap, 2 is a snap, and 3 is a stamp. Okay? And now in pairs, we have to alternate. If I am doing 1, you are doing 2, I do 3, you do 1, 2, 3. You see? Okay. Example. 1. No. 1. Oh my gosh. Perfect. Okay. Higher. 1, 3. 1. Continuous. 2 is a snap and 3 is a stamp. Higher. 1, 3, 2. Too confusing. I'm glad we have all woken up. We are ready for the next session. We will play the game during tea time. Have a seat, everyone. Welcome to the next session. Yes, karibuni sana to the next session. Still under the Standing Committee on Children, the NCAJ Standing Committee on Children. Before here we had a simulation. That was actually an example of a court user committee. We had the magistrate, we had the children officer, we had the probation officer, all actors involved. And now the next step, the next stage is the next steps of action. What are we to do next? We have identified the gaps. Now it's action time. So allow me to welcome Ms. Juliet Gashanja, an expert, a child rights expert, if I can call her that, because this is a committee member who has been very committed to child rights. And I think we have interacted with her before, some of us. She is good at what she does. Allow me to welcome Ms. Juliet Yanyayo. I know I'm Gen Z. Tutafanya Yanyayo. Haya, 1, 2, 3, funga. Which one is first? Okay.
Good afternoon. Karibuni everybody to the afternoon session. I was saying to Mary, this is how you know you're Gen Z. Thank you very much, TDH. Thank you, Judge. Thank you, Dr. Steve, and everybody who's here for giving us this opportunity to brainstorm on the justice according to the child. You know, that's the question that was posted on LinkedIn and everything that was shared for this conference. The question was what is justice for the child? So it's been, I feel like I've gone to school again, and it's been very informative. And so we are here to ask the and then what. So I'm not doing this alone on the program. I'll be joined by another Gen Z. Because we have to pass on this baton. Judge Madeka and the Chief Justice passed it on to us, and now we are learning to pass this baton to others. And so I'll invite Karen as well to come and introduce herself. And then Effie tells me that we have one question online, so we are going to take that question as well.
Good afternoon all. I'm not Gen Z, just to be clear. Don't be fooled by my appearance. I'm a millennial. My name is Karen, as you heard from Juliet. I work at the Center for Moods and Research Africa, which is a small budding NGO which I formed with a few of my colleagues about 2 years ago.
Excuse me, we can't hear you. Oh, I'm sorry.
You can hear me now?
Yes.
Yeah, thank you. So I was saying my name is Karen Koech. I work at Center for Moods and Research Africa as a head of programs. It's a small NGO funded with a few friends of mine just after admission. Our intersection with TDH is we do legal aid for children matters. So that's where I met up with Effie and got connected with TDH. Yeah, and that's how I found myself here. And yeah, as Juliet has said, she's passing the baton. So I'm here to learn and also do and work on, learn on the job.
Yeah, I think before we actually carry on, I know there is a magistrate who joined us from Isiolo. Nash? Please, are you here?
She's not in the room, but
she's around, yeah? Yes, I want to recognize and allow her to introduce herself. I know we have students, or former students as well. We have the chair of Wakili wa Watoto. We are also passing on the baton. Please stand up and say your name.
Good afternoon. My name is Belinda Mwendediga. I am the chairperson of Wakili wa Watoto, which was established by the National Council on the Administration of Justice. And our mission is very simple but profound, to ensure children are protected, their rights are promoted, and their futures are safeguarded. So thank you so much, and I'm glad to be in your midst.
Great. Any other student maybe? So this is, I think it is important that we do that because these conversations will not end here. I was a child when I started the work on child justice. I was a child. And now to see other children join me is amazing. Yesterday we had an actual child, and to see students doing that. I'm told there's another student here who does not want to introduce herself, but
hi everybody.
Hi.
My name is Nicole Motoso. I'm a legal intern currently at the Supreme Court of Kenya.
Great, thank you very much. So it's important that we recognize who we are passing this on to. And I am a lecturer, so this is why it's also important for me to see our students doing and taking on this baton. And it's part of our way forward, honestly. And I'm proud of, Rosie started the Wakili wa Watoto Club. So you can imagine as well, and she was working at the Supreme Court, and so this progress is important for us to take note of. This is how the justice system works. Kathy, maybe do we take a question?
Yeah.
Good afternoon. I'm not quite sure who's going to answer this, our judge and our magistrate. Probably this will be for you. The text highlighted is Section 8(5) of the Sexual Offences Act. It is a defense to charge under this section if it is proved that such child deceived the accused person into believing that he or she was over the age of 18 years at the time of the alleged commission of the offense, and the accused reasonably believed that the child was over the age of 18 years. And 6, the belief referred to in subsection 5b is to be determined having regard to all the circumstances, including any steps the accused person took to ascertain the age of the complainant. Now the question is basically, she's giving a scenario where she works. She has been an enforcement officer and an officer in Kakuma and currently in Kiambu. And the question is basically how many times people get charged with sexual offences for having sex or sexual conduct with minors while they were under the assumption or reasonable belief that the accused was an adult. How then do you handle
the victim was an adult? The victim, not the accused.
the victim? Yes, sorry, the victim. Well, they're then under the assumption or reasonable belief that the victim was an adult. So on deception and reasonable belief, how do you prove that the accused was being deceptive, or how do you handle such a case?
The burden usually shifts to the accused person. There's a defense in the SOA that if you are led to believe that this was an adult, so it's now upon the court to determine the threshold. There's actually a threshold in the SOA that either they told you they finished from 4, they told you they had an ID, they were forgotten at home. So it's surely a defense. So it's now it's the court now to make a determination whether it was sufficient.
I think if you read the section, it will tell you that if it is proved that such a child deceived the accused person into believing that he or she was over the age of 18, the accused believed that, and then it says that the belief referred to was to be determined having regard to the words, including any steps the accused person took to ascertain the age of the complainant. So you can see it's the accused who established to show the court that they did something to understand, to see the age of the, that is, he has to tell the court, this is also what I did to ascertain the age. Usually I say, if you're not sure, ask how old are you? Do you have an ID? You say you're above 18, you know? Yeah, I know Prof is Dr. here is laughing, but it's a serious matter. And the men should know, I tell them. At the end of the day, when you put a woman at work, so if you have a young girl, maybe she looks 16 or just around 18, because usually around 18 is young looking. Why don't you tell? Ask for an ID. Go ahead and ask for that, so that when if you wonder, you have something to say, look, I did, this is what she showed me something that she's actually about. So at the end of the day, the man has to, the burden.
There is a follow-up. Is it sufficient to show that the girl had a Tinder account, considering Tinder requires you to be 18 and above? Does that count as sufficient evidence to prove deception?
No.
No.
But you submit your ID to Tinder, I don't know about Tinder. What is Tinder? The young man, my age. Okay, by 10 years. No, does it ask you to submit your ID?
No.
Does it ask you to submit your ID? Does it ask you to submit the ID? It doesn't. So you must only.
No.
But I don't see children. Some children, in fact, there's one case I was having, and the
child has crammed the ID, the parent's ID number. So they submit as that parent. So that is not proof enough. There is one case where the accused person told me that the child wasn't going to school, and I asked them, why aren't you going to school? He said, I finished, it's only that I haven't paid school fees. So I can't get my living certificate or anything. So I'm like, for you to have gone ahead to even ask, why are you not in school? That was defense in our But there was also closing age. You can see a child, honestly, the same way I was saying, it takes at times common sense to know this one is looks like a child. So if it walks like a duck, walks like a duck, then of course it's a duck.
I hope that was captured on the live stream, because the question came from an online audience. Thank you.
Good afternoon once again. We are almost at the tail end of this conference, and just for a refresher, give a brief on what we've been learning so far, what we've been hearing from all the awesome speakers we've had since yesterday, and then I'll invite you guys to come and tie it all up, of course with your help. This is going to be a joint effort to see what really are we taking away after sitting for 2 whole days in this room. So we've had a broad array of speakers since yesterday, representatives from all the agencies, that's the judiciary, the ODPP, the police, children officers, as well as the civil society organizations. And we've seen that a common thread has been the urgent need for a coordinated, child-centered approach to justice, which prioritizes, of course, the best interest of the child. We've seen speakers highlighting the fact that there are gaps that need to be filled. For example, need for referral systems, prioritizing diversion, and of course, I'll insist upholding the best interest of the child throughout all these processes. It has been pointed out that there are inconsistencies in implementation, the need for trauma-informed support services, and of course, the involvement of children, which came out in the last session yesterday, where the children were speaking here, and they're like, hey, you guys are so boring, what have you been saying? Yet you're speaking about children. So, that said, there were also positives that were pointed out by some speakers who said that the wins, such as the increase in the age of criminal responsibility for children, the incorporation, of course, of HIS, and also just the willingness of all the agencies represented here to center the rights of children in their work. So what does that bring us to? It brings us to this session, where now we'll be speaking about what's the way forward, what are we taking away from the sessions that we'll be having. And I urge you all to interact as we come up with these solutions for now and for the future, and of course for the best interest of the child. Welcome Juliet to come and lead that session. Thank you.
Great, thank you very much. So, colleagues, I have one question. So what? And then what? Where do we go from here? I was telling Judge and Linda and Patricia during our lunch break, that I was going to aim for a boxing ring where we fight it out and the child refs it and we see who is the winner at the end. And maybe out of that we can develop some fighting, what are they called? Fighting rules of war when it comes to children. And especially because it's child justice. And for me, I don't just look at children who are in conflict, I'm thinking about the child who is in contact with the law. And then what? So with what Karen has provided us with, yesterday Dr. Akoth reminded us that children experience most of the child justice gaps, but also that a lot of these cases are not reported to the justice system. Today, African justice system was expedient. The decisions were made and everybody was involved. So very much like the skits that we watched today, I don't think that is necessarily what happens in court. The few times I have attended court, they don't sit at a round table and all discuss about the child and look at the child in their eyes. Sometimes the child is somewhere else, the magistrate is up there, and and I'm not talking about children's courts only, I mean, all over the country. In some places, we don't have that kind of a setup. So today we're reminded that the African justice system is expedient, and everybody is involved. And on all through the conversations, we talked about the alternative justice system that acts as not just a dispute resolution mechanism, but also a facilitator of this thing we call justice. But that can also have, and today's Jemima's presentation, she mentioned it like that the AJS committees, even in the community, can have this sort of supervisory role when it comes to diversion programs. So, and yesterday, Linda reminded us that that it's also that we work, unfortunately or unfortunately, that all of us represent some form of a system. So when I'm trying to see where do we go with all this. We have a system, we have the child, we have the laws. So how do we operationalize them? And as Karen has said, to the best interest of the child. Section 3, Judge, were reminding me, was it Section 3 or the best interest of the child? Section 8. Yes, that talks about the best interest of the child. And how we, all of us, are bound to apply the best interest of the child in all decisions that we are making, in our coordination, even in administration. So, we want to develop something at the end today, at this point, that will help us to put into implementation or to operationalize all these conversations that we have been having. And so the first question I have to all of you is, what is this thing? This tool, what do we call it? Do we call it a framework? Do we call it a guideline? Do we call it a direction? What should we call it? That is the first question. The second question, who will take up ownership? I hope somebody is writing these questions down. Yeah? Who will take up ownership or the leadership of this process? Number 3, how do we operationalize it? So what is it? What do we call it? Number 2, who takes the leadership or the ownership? Number 3, how do we operationalize it? What are the mechanisms that we put in place to operationalize it? And I'm going to give you, because we haven't had a chance to talk to our neighbors and work together, so I'm going to just allow us to work across the tables or the groupings as we are. But as we're doing that, ladies and gentlemen, allow me to remind you that as we are working in systems, in programs, in all this, we are guided by 4 principles that we agreed as countries in Africa and abroad, everywhere. We agreed that for the rights of the child or for children's rights to be enforced, that will be guided by the principle of survival and development. That is 1. So we are seeing the child today as a 5-year-old, as a 7-year-old, as a 9-year-old. Remember, we say that even the child who's committed an offense who's below the age of 12, we have to think, what do we do? We can't just assume that they didn't do it. But they've done something, but how do we correct them? So, but we are seeing them as a 5-year-old or a 7-year-old today, but tomorrow they will be Effie, seated here, contributing to the society. Number 2 is the principle of the best interest of the child. That is another guiding principle. We can even call it our efforts. So that every decision we are making, every administrative process we are taking through, we are thinking of the best interest of the child. What does that mean? There are countries that say, you know what, we need to define what our best interest is. I'm happy that our law, Section 8 says what it is, and then there's a schedule that actually, really delineates what that means and some of the considerations that we ought to make when it comes to the best interest of the child. Number 3, non-discrimination. That is the other guiding principle. So that when the child walks into our office, courtroom, wherever else that we meet them, whether we are sitting in as an AJS committee or we are sitting in as a wazee or nyumba kumi, we're not looking at a girl or a boy and treating them differently because wasichana ni watukutu ama vijana ni watukutu. We are looking at them as persons below the age of 18 who have a future. Number 4 is child participation. That is the other guiding principle, child participation. So what is the voice of the child? Last year when we had the AJS conference, one of the conversations that went around was that when the committees, the AJS committees sit down, ile nyumba ya wazee, kikaa chini, watoto na wamama, they don't participate. Ama they don't consider the voice of the child. Because ideally, when I grew up, watu wazima wakikaa chini kuongea naambiwa, enda bedroom, watu wazima wanaongea. And so there was that question that came from the plenary, how do we ensure that the child is participating? So there is the part of the child participate, like sitting there, maybe giving their views, but how do we ensure that those views are taken into consideration, and does the child know that those views have been taken into consideration? And lastly, the other guiding principle, as I said earlier, is child protection. Child protection. Child protection comes from the concept of that yes, children have rights, but we acknowledge that they are becoming, and therefore they must be protected from all the issues that they are vulnerable to. And so therefore, us as adults, we have an obligation to make sure that we protect those children. So those are we consider that is our ethos. We consider that's our philosophy. That yes, we work in silos or programs or systems or whatever it is that we want to call it, but these are the things that are guiding us. Because at the end of the day, we want a Kenyan child, I assume, who is healthy, who is going to school, and who will grow up and contribute to the society that we live in. So, answer my questions that I started with, and I'm hoping that those principles, those are called the child rights principles anyway, that those principles will help us to really understand. So, I would encourage that you look, I can see Anne is one person, so just look back, those 5 are your group members, here 5 are group members like that. So I think where you are, if you're in groups of 5, just sit together and answer those questions. What is it we are creating? What is that? What do we call it? It's a framework? Is it a policy, direction? Who is the leader? Actually, and lastly, maybe I'll add another question, and what is our role? So whichever office or whatever role or whatever profession you represent, define your role within it. And this is all towards access to justice for children, and especially children in conflict. We will have maybe about 20 minutes, and we will go around, well, maybe 15 minutes actually, sorry, not 20, 15 minutes to discuss that. And we will, please appoint a rapporteur who will actually type out whatever you discuss so that it can make it easier for us to put together. So in groups of 5, time starts now.
Yes.
take feedback. We'll, I think we just go. I think you identify your rapporteur, so I'll invite the rapporteur for this first table, the second table, like that, and make your presentations. Also, please, I recommend that you type your, your presentation, and then we'll give it to the secretariat. Effie and Marioth will send it to them as well, so that we can put it together and start working towards whatever we'll call it. But I can guarantee you that by the end of the next 45 minutes, we will have decided what it is going to be. That is a guarantee. So I'll invite this first table. But let's take about 5 minutes each. Yes, from project. Projection, yes. We are serious people. I belong to this table.
If you're not projecting like our table, you can come and
Yes, yes.
the format you have, and then you will bring outside.
The second. Please come and share. If you're not projecting, as we are waiting for them, then they'll have to wait. You're projecting. Who is not projecting? Come and present. All right. Tell me a group work imeisha. Ladies and gentlemen, tell me a group work imeisha. So let's pay attention.
Gentle person. My name is Nyaranga Odundo. I hope you missed me because I missed you. I am presenting on behalf of my so we kind of took a more practical approach to our answers to the questions based on our practice experience. So I have the privilege of having in my group myself, 2 members from ODPP, and a member who is currently interning at NCAJ. So we had a wide array of perspectives. So our first one was, the first question that we answered was, what do we call it? Our suggestion is framework for diversion pathways for children. So, of course, children in conflict with the law, because we are assuming those are the ones who are being diverted. That was our first suggestion. The second question that we answered is who is responsible for this? Like, who kind of holds the biggest responsibility when it comes to this framework we are suggesting? Again, lived experience and even the simulation that we did here earlier today, our suggestion would be that it be a combination of the ODPP and judiciary, just because of the experiences. Of course, we have established that diversion by other definitions takes place from the home, from the chiefs, from the police, all these authorized officers who are doing versions of diversion. But when it has escalated to the point of we are having, a court involved, we recommend that the ODPP and judiciary be in charge. The third question that we had was how to operationalize. So our perspective is that it is already in operation. We might not have similar pathways, but diversion is something that is and has been happening for a very long time. Just to give a few practical examples, where I would say the ODPP and the Children's Office were very much learning on the job. We had a young boy, this was in 2021, so the age of criminal responsibility was 38. He had been brought to court by his grandmother for stealing 500 shillings. And after discussions with the ODPP, after discussions with the Children's Office, we established that this is not, first of all, number one, it's 500 shillings. Number two, it's within the family. This child was not a criminal mastermind by any stretch of the imagination. And from what we established, though his mother was alive and well, she was not participating in his care. She had left him at his grandmother's house. CBC had just dropped. His grandmother had no concept of what CBC was. So whenever he asked for money to buy materials for CBC homework, she would refuse to give it to him, na akienda shule anachapwa. So his solution was, nikipewa pesa ya kwenda dukani, I will not return change. I will come and buy the things I need for school and take those. So we were able to work together, the ODPP ourselves. We found an institution that was able to provide him with education, a place to stay, and also to provide counseling to him and his family. Happy to report that now at 15, he is the lead trumpeter in a brass band at his school, and he's currently in high school. So it's something that is already happening. Maybe not just, I believe not just at Milimani law courts, but at different court stations at different levels. Everyone is already doing the work. We might, we might call it different things, but it is work that is already in motion. Then as far as roles, I already explained the members that were in our group. From the Children's Office, we feel our most important role here is to identify the social circumstances of the child or children in conflict with the law, as well as diversion pathways. After that, also, we think another important role is the supervision of that diversion as directed by the court. For the ODPP, of course, it's to make the decision to charge and to identify, analyze whether or not a matter is suitable for diversion. With our member from the NCAJ, we were talking and we feel like some of the work that the NCAJ can do is to empower actors, both professionals and the children and families and communities themselves, to know what is this njia mbadala that you keep bringing up. How is it done? How can it help us? Because it is very important to understand that these children don't exist in a vacuum. When they go back to a community that doesn't understand that they have offered restitution for what has happened, they'll still be in a very hostile environment that may not be conducive to their growth. So yes, even though sisi tumeona hata kama hatuna the tech know-how of Patricia and friends, we hope our message came up. Thank you.
Okay, the presenters, are we ready?
Not yet.
Oh, not yet. Okay, who else is not presenting? Okay.
So for this group, we also currently need a framework. Of course, the name will be defined much later once we agree on exactly what we want to churn out. So a framework for the version, the name will be found at that particular time. When it comes to who takes leadership, we felt that the government should take leadership because we want this process financed. So financing from that level to ensure that whatever agencies, it's the ODPP, it's the judiciary, State Department, probation, whichever police, they need to get that.
Who?
AI,
I need
government.
to know. Who?
Okay, we're saying government, so like anchoring, what we're thinking is, can it be anchored probably through a constitutional process? If not, a law specific, to just ensure that we get a budget, because currently what we are struggling with is financing this process. Both the children department, they do not have funds to facilitate or ensure the reversion happens. Judiciary, of course, they're still struggling with finances, as much as we have our own kitty right now. The police, the same thing. So how do we ensure that we get finances allocated to facilitate this program? Because we're looking for programs. Where do we get programs? They need to be financed. And for sustainability, because we can't say we're going to lump it on children department or the police or the judiciary. Of course, the judiciary and these other aspects will be part of the government, but then with clear-cut, direction from the top north, where everyone gets their mandate, everyone gets their allocation in terms of budgetary financing to ensure that diversion really works for our country. How do we operationalize it? Of course, financing, that is the first thing. Of course, doing the framework that we'll be developing, coming up with a toolkit that will be used to now sensitize and ensure that everyone appreciates what exactly we want to achieve. Then clarity on the protocols. Who does what, where, how for these children, what our role is, what budgets are anchored where, because I know that's where our problem is. Of course, coming up with a tracking or a system that will help us collate data, because that's a struggle we're having right now with data. How many we churn out, what are the success stories, what are the gaps that probably need to be addressed,
So yeah, and also help us in monitoring this process, the diversion conversation in our country, and be able to just identify gaps very fast and be able to implement the same. Yes, and of course, lastly is to our role. So we felt that our specific roles will be complementary, but also facilitating and contributing to what the government agencies that will be allocated here, which is the judiciary, the police, Department of Children, AG, if at all, judiciary, will be able to speak into this conversation, but also just ensure that we complement by doing sensitization. If at all we get funds, be able to support some of these aspects because the government cannot anchor everything. But also bring in and diversify the program because, of course, we are in this together and we need to contribute to this process. So yeah, that's basically what we say, but we want this to be anchored at a very high level of the government. So again, judiciary taps on that. So that's the
High level of government demand.
like, okay, like for example, what we're seeing with the probation, it's, there's so can it be anchored somewhere? The correctional services, where can it be anchored there? So then we can get our budget to finance this process.
Thank you. Hiyo group hajamaliza assignment, lazima mtuambie serikali ni nani. You have to tell us who it is, must. So mrudi hapo mfanye malize assignment. Group hiyo ingine yenye hawa present.
Good afternoon, everyone. We were a group of 5 with quite a tussle between the various state actors. So yeah, the definition will be done at the fleshing out of the name itself. So we call it a framework and then it will take on from there. As for ownership, we're also for the government, but specifically now, the NCAJ Standing Committee on Children, because who better to consolidate and assemble everyone like their relatives than NCAJ itself. So yes, they are the ones who have a very magnificent mandate. You can even sit right there to ensure a coordinated, efficient, and effective and cost-effective year. So NCAJ is the best person to task this with, to follow up and bring on people. Now the bone of contention will be we don't really understand how the membership works necessarily, but in offering our solutions of operationalization, we did note that it is important for, of course, now for the various stakeholders to be brought together. So now that would be NCG to guide us. And of course now we can support them as non-state actors and all the other partners in consolidating the various stakeholders to consult whenever we're having these discussions. But generally I think there should be a solid membership and then from then on, we can cascade it everywhere. And then now moving on to the operationalization of the same. The first one we definitely highlighted was training. That's refinement of the various curriculum in everyone in the justice system. So we know that the judges are pretty good. They could definitely be trained furthermore, but yeah, there's that. But then you find that there are, we're just joking on the table that there are people who are still referring to the Children's Act of 2001. Imagine. So imagine, if people are still referring to that, then that means there's a very huge disconnect, especially with the police. So we're being informed of when the police have on the Africa Tips, the Anti-Corruption Act, so why would they bother knowing about these relevant people? So it's important for us to train the relevant stakeholders in that. The other one, I believe one of our colleagues has mentioned, monitoring and evaluation. I believe it was highlighted here yesterday. And many cannot be understated in today's world. And with data, conclusively and over time, can definitely inform your perspective. And for you to actually know where the problems are coming in, you can always go back and be like, okay, so we saw this problem coming from here, and so this is the best way. It would actually help us even nab things nip things in the bud. So just like in medicine, when you're told to go for your regular checkups, it's the same way we say that. In this case, people definitely have to focus on that. The other thing, we would definitely highlight the utilization of the evolution. I believe those are some of the state actors that we definitely don't usually focus on. Devolution, as much as it's a reality, is quite usually forgotten. Yeah? And so that, of course, helps with participation. And I believe now through the counties, the various counties, we can even be able to get the relevant children and, of course, now all the way from baby and all the way to 17. So, yeah, and of course, now that we're also bringing in the relevant county stakeholders to also be involved in the same. Now, moving on to the next one. My colleague had pointed out that we also need to identify the risk factors, so I think that ties in with MME, so that we can identify all these things as they go forth. Now, finally, moving on to one last one, sorry. I don't know if digitization could play an important role. And if we talk about digitization, if you look at the justice system, from the police all the way to KPS/PACT, Rwanda is a very, very good country on how they have synergized the entire system, from the police station all the way, because truth be told, judiciary has their own system, KPS their own system, State Canada their own system. So if we were able to digitize all of these relevant, so all of them of course can have independent systems, but they should be harmonized in such a way that I won't struggle to get information from. If I need to refer back to what happened at the police station, I can always go there and do the same. We know with Kenya it's happening over time, but I think we can of course look for ways to support as partners and stakeholders in that. Now moving on to the final bit, which is our roles. Definitely the standing committee will require resources. And so the government, of course, even as it continues allocating budgets, we know they don't allocate enough money. And so it's up to us as relevant stakeholders to go and source, because I believe even the judiciary itself has a resource mobilization. It came with a new CJ. I'm not sure if it was there with CJ Maranga in Americas, but I know under the new CJ it's a very important mandate. So resource mobilization will definitely help NCJ, of course, fulfilling its mandate. There's important, we can definitely support them in sensitization, because if sensitization is not done, then people will continue relying on Children's Act of 2001. And then, of course, now our role is also in ensuring participation, and of course, we always see checks and balances, but we can definitely involve, ensure that if they need participation in this particular way, we can definitely go on the ground, consolidate the people, and bring them there. It's all about partnership, really, when it comes to the various roles of the various agencies. Not all of us can be represented in NCAJ, but we can always look for a way to, perhaps in consortiums, consolidate, meet, and then give over our various feedback and give over our sentiments to our representatives, and then we check to ensure that it's literally just whatever it is that we have given out. So that is what we have to present. Thank you very much.
Next group that is not presenting.
So hi everybody. So the group I was in was made up of UNICEF, Terre des Hommes, CMR, and there are 2 interns, one from PETA and one from the Supreme Court. So for us, it was kind of decided that we have a student kind of give the presentation, because as was mentioned, we are the future, almost present stakeholders of this. So for our group, we decided that the name of the document would actually go towards action plan, to serve as a general framework that we can use to guide a more detailed framework down the road. And the argument was that the NCAJ can take primary ownership of the action plan, with all of the other organizations serving to provide a collective backing towards it. And operationalization of the document, first and foremost, to identify and clearly define the role of each agency, and to clearly outline the criteria for matters for diversion and implement the current guidelines fully. Additionally, commitments by agencies in developing coordination mechanisms in the grassroots and the mapping of diversion programs on the ground. furthermore, continuous sensitization of all actors, as was mentioned by the previous group, as well as piloting the program in specific areas. So this particular one would work in contrasting areas, some with better frameworks in place than others, so we have a bit of an idea throughout the country of how best to implement it given different circumstances. And continuous sensitization and research and documentation tools for diversion through monitoring and evaluation. And so the roles were kind of described by the different organizations. So for UNICEF, the role would be to support implementation of the framework and the piloting, whereas for the civil society organizations, including CMR Africa, the development of the monitoring and evaluation tools, the piloting and sensitization. And I believe I've covered everything. We left out obviously the organizations, or rather the Supreme Court and FIDA, just because our stakeholder as interest is not that big, but obviously at some point these two organizations will also play a role in this. Thank you.
Assalamu alaikum. Representing Temetu, Kaiti, Kati African. Thank you. So, question one, what should we call it? One dilemma between calling it a framework or guideline, but we can actually call it a framework if it is going to focus on policy issues, but we may also consider guideline if it is going to focus on maybe step by step or the best practices in terms of diversion. Then who will own it? We thought that maybe the lead agency here should be the ODPP, being supported by judiciary and the NCAT. Then how do we operationalize it? Maybe we need a clear institutional structure, especially like if police have to divert this case, then they have to work with ODPP, they have to report to ODPP. If it is at school level, then the teacher has to consult ODPP. Let me just give an example in reference to crime scene investigations. Normally, in processing the crime scene, it is the role of the crime scene officer. But you realize that we don't have crime scene officers in all police stations. So if we encounter a crime scene, sometimes by the guidance of the crime scene officer, even other officers are allowed to document, then it allows the crime scene officer to hold the whole process. So we feel that even for diversion, if you have to initiate diversion, then first of all you have to consult the ODPP to be able to guide you and to be able to report data on that. Then also develop SOPs just to guide the mandate of different service providers to effect the diversion process. We also need to establish committees at the community level, especially to facilitate diversion quickly. Then resource mobilization will be key in supporting capacity building of service providers and other key stakeholders. And then also create a monitoring tool just to make sure that we are able to work within the required framework. Then the role of what is our role? I know it has been spelled out by the other groups and I don't want to repeat, but let me just emphasize on there are areas where referral will play a key role, especially like if within the health facility they discover that this is a criminal offense, then sometimes they just need to refer because they cannot investigate or conduct the preliminary inquiries. So referral again will be quite key to the relevant agencies who have been given the mandate to carry out that. So thank you for listening and I hope I was the last few business.
Good afternoon. My name is Belinda. I was with Anne from the CS, Mary from NCAJ, and Penina from media. So when answering the first question, what do we call it? The first question we ask ourselves is what is the end goal of what we are doing? And then we aim to work retrogressively. And then now we came up with the topic, practice directions on diversion for the justice system. That's where we create linkages for every actor. And then the second question on who will take up ownership. We agree that NCAJ, since it encompasses state actors and non-state actors, and also the National Steering Committee on AGS, because they're already doing something about it, so we can also borrow a leaf from their book. And then that question on how do we operationalize it. First is setting up a matrix. Like you said, setting up roles and implementation. We noted that for instance, the reason why we have the three arms of government, one thing they do is acting as checks and balances. So when we have clearly defined roles for each actor, then you can act as roles. This actor is supposed to be doing this, why are they not doing this, and then you come back again. Because it's been here, the diversion has been here, so let's see what everyone is doing and acting as checks. Then you can also have timelines as well as SOPs. Then the other one is we have to benchmark the counties where it is working and those that are not working, doing a benchmark of where it is working, why it is working, and what can we borrow from it. As well, in as much as we do the benchmark within Kenya, let's also do a comparative analysis for countries where it is working, what can we borrow and what can we implement in our processes. And then we can also do a pilot and see what works, and also data collection. In data collection, we also have to involve children, because as you know, you cannot have conversations about children without having children present, and also putting in mind what, like they were here yesterday, they said the same thing. We were talking, they were not understanding what you were saying. So if we need these processes to work for children, then what are children saying? Yes, and the roles that we had laid out have already been discussed, so there's no need to repeat again. So that's it.
As you can see, this is our PowerPoint presentation. So we started with what name we should call the tool. And we agreed that it could be a framework of whatever choice. But we chose to call it the AGS framework for the child justice system. And who will take leadership? Considering that there's an existing committee on AGS, we thought that this is a good opportunity for the NASCI and NCAJ Standing Committee to work together, because again, we have different representation from the different actors. So lead role could be, of course, the AGS committee. How do you operationalize it? We thought of having practice directions. And you might ask yourselves, why practice directions? Both these committees, are constituted through the judiciary, and then there's practice directions then that can follow from it. However, it doesn't say that we are stopped within our different institutions from having our directions. Please remember, when we talk about AGS, it's just not diversion, it's the PI process, the preliminary inquiry process that you saw here. It's also maslaha, for as long as it's not repugnant to justice and morality, when we say that. Of course, there's going to be different ways we encounter AGS. So this is encapsulating all those different AGS systems. I know we focus a lot on diversion, but I just wanted to remind us that there's also the other AGS systems that are there that we can also consider. And what is our role? In our group, it was myself, Honorable Kibosia, Judge, and Doc, Professor Doctor. And for the advocate, we can propose to court whenever we think that maybe the court can have a look or consider that. Of course, we can draft relevant pleadings to file the case of the children whenever they are encountering these systems. Judiciary's role, of course, is to divert in such cases, if need be, to create awareness and to adjudicate within the different forms that are there. And I think there's also the referral process as well, that maybe, Judge, I think maybe we could have also said that the judiciary can also refer to a system that it thinks also can handle if it is brought out and if it deems fit that that system is appropriate as per the Constitution. And then the role of NASCI, the AJS, is to research, publish, train, influence, and also influence future legal education. Because when we're talking to Professor Doctor, told us that they do a lot of research on the area, they publish a lot. They've also been training different stakeholders on it. And the other ways, of course, is what was mentioned earlier, that maybe child rights as a module can be a mandatory module in the law schools and not relegated to an optional course that is taken. I don't know if there's anything I've left out. Thank you.
Thank you, Patricia. She forgot to say that I was out in that. Another group for presentation. Is that it? We're done? Great, perfect. So I'm going to show you what we came up with. I was typing out as we were talking, but I might not be able because I have to send this as an email to everyone. But we do have, my work here is done, and I'm very happy that we came up with something. So there was a couple of proposals. I said that at least we will leave here with a name. So there was diversion pathways framework. There was a framework for diversion. There was a group that said framework. Another one said framework. Another group said guidelines/framework. And another one said practice direction for the justice system on diversion. And another one said the AJS framework for the child justice system. There are two unique names that we have there. No, actually three. There is one actually had something to write, but anyway. The one group said diversion pathways framework, and another said practice direction for the justice system on diversion, and the other one said AJS framework for the child justice system. Should we vote? Should we pick one so that we can leave here with a mandate to start working on something? Effie and Marriott and the rest of the team can start, and the AJS committee as well can start working towards this framework. Please take them out because you're projecting, so you can type it out. Diversion pathways framework. And she's like, no, so I cannot project for you. Just send it, and then I will be able to project it. Okay. It's easier that way. As I'm projecting that, one of the things I've learned was the conversation about roles. And I think one group said that it is important, I think it's the group of Mr. Songa, where he said that we need to start putting the diversion committees in the communities. And I remember when we visited Kakuma, the CUC decided that, yeah, Rosie was there, so, decided that they're going to become, instead of this squabble of who can do what, decided to formulate as a diversion committee. So that literally, when there's a case of children in conflict, maybe we should go back and ask them for data now. When there's a case of children in conflict, they sit together as a committee and agree on the action that they will take to help the child. So I think that is, you know, a good practice to pick up on. I just want us to vote on the name, and then my role will be done.
We cannot match those.
We can merge them, yes. We can also merge them, yeah. Let's see. The round structure. And just scroll down to the table. So this is what we have. Can you all see? These are the names at the top there. So we have the unique ones, as I said, was the diversion pathway, the practice directions, and the AJS framework.
Because not about diversion only.
Yes.
Maybe we need to.
Where's the other microphone? Miriam?
Okay, thank you, Mwalimu. Because it's not about diversion only. Maybe we need to, because there are other things, mediation, because it's for the child justice system, isn't it? It's not about children in conflict with the law, right? Yeah. So probably we need to bring them together into one, include AJS plus all the others. So the others are not diversion, so I'm thinking we can add them to the AJS program.
All right, so judge proposes that we keep the AJS framework because it is all encompassing. Leader's hand is up. Please give me the
I would choose the first one, diversion pathways framework, because it's something that we already know what diversion is. I think it's just about streamlining this process of what we call diversion. And it can encompass so many things as per the Children's Act, as per documents that have already been created on diversion. So I think right now, we can start with a diversion pathways framework just to ensure we concretize the practice of diversion, which is what is provided for in the Act.
Okay, so there is a vote for the diversion pathways framework because we already know that that is in existence, and streamline the processes. Another voice. I wonder if our child, you know, our last one here, seated far at the back. Yes, Omar. And he can tell us what he thinks. Omar? Members, this is our work. This is our process. We have to leave here with a name. Thank you, Patricia. Anybody else who has an input? We've heard from the judiciary, now go with mandates. We've heard from judiciary. As a study committee. Yes.
Because for me, all the children.
Yes.
The ones with conflict, the ones without, the custody ones, the maintenance, all the children.
Good. So judge represents the child. I'm walking to the police.
Hi everyone. Hello. I'm Guy Musa, the judge. The judge page is the mark commission case.
Okay, LRF.
I've been following through the conversation and I'm seeing the different suggestions that have come up, but I believe that the conversation that we're having, even from yesterday all the way to today, is dealing mostly with diversion as a method of ensuring that the child justice system is working for the child. So I believe even the name that we are going with should be in line with diversion. So I think the diversion pathways framework would be a really good title to go with this. Yeah.
All right. So diversion pathways. And
I don't think I have any contrast with what you have said. Yes, thank you.
thank you very much. Rosie?
I'm just reading section 226 of the Children Act, which talks about the objects of diversion. And it says the objects of diversion shall be, I'll just paraphrase, to make use of alternative methods of holding children accountable for their unlawful acts or omissions, to promote rehabilitation and reintegration of the children to the family, back to the community, to encourage symbolic restitution, to promote reconciliation, and I'm thinking these are some of the aspects contained in mediation, AJS, I think the other ADR methods. So my proposal is to retain, maybe call it National Diversion Framework or the Diversion Framework. I think pathways is a bit limiting because when we say pathways, it's just talking about the referral mechanism. But when we talk about a framework, it will be wider than the pathways. It will be wider than the referral mechanism because we have a consensus that the roles and responsibilities need to be better defined.
All right, so Rosie has proposed that let me just that we call it more of a framework for diversion, because pathways is mostly about the referral pathways, but you say we can enhance that. I just want to show you something, the diversion toolkit that we were talking about. So as DPP was developing their policy, the standing committee, the then task force on children matters, was also developing the diversion toolkit, and we've heard it being mentioned today. And even though the process the process ended developing it, the rolling out is what was remaining, but this was done before the Children Act 2022. And it essentially really talks about, and I just want to show you this outline. And this is what it has. So it contains what diversion is. And you can imagine, at the time when we were developing it, there is no law on diversion. So it's not even like now where we have all these provisions. But we borrowed a lot from everybody else. And in Kenya already, we were implementing diversion through the children, the State Department for Children Welfare Services and other NGOs. So this is, we borrowed from that practice. And one of the things we agreed on is at least on having this eligibility criteria and the roles. Now, when I think it was leaders who were making the presentation, they say that the one in charge is judiciary and ODPP at the point which is there is charging. So I imagine that there is then a pre-charge and then post-charge. Yeah. She said that I was just taking what she said, that judiciary and ODPP will be responsible, right? When I asked who are the persons responsible. So there is the point which is at post-charge, then I assume that there is pre-charge. So anyway, so those are the approaches. So there is pre-charge diversion and post-charge diversion. And this is how the toolkit look like. And then of course the crimes that are eligible for diversion, referral pathways, which is what we are talking about, and then the roles of the stakeholders. So my intention of and of course now the various options that are available. My intention for showing you this is therefore to recommend, just from where I'm sitting and from looking at all these documents, is that maybe our role, our work really, our homework, is to enhance this document so that it fits within what the conversation that we are having, and adopt the provisions of the Children Act 2022, because that is what is lacking, includes the provisions of the ODPP policy, which I think it did to some extent. So include those provisions, and then see, and then now operationalize it, and use what you have presented as an operationalization strategy to roll it out. I like that conversation about piloting, for example, in one area, and then taking the evidence and the successes and take it to another area. So that is what I want to propose to you. We have so far agreed at least the name ought to include, please give Linda a microphone. We want to include the name diversion within the framework, right? So we have a diversion framework. So far we agreed at least on that. Whether we will include the name AJS or the name pathways is yet to be agreed upon. But at least we have agreed that what should be included is also a referral mechanism and roles for every actor.
I have a question.
Yeah?
What do I do with the rest of the children matters? Because where else would we get a forum? Let me have a mic. Thank you. Where else would we get a forum to talk about the other aspects of alternatives, the mediations, the whatever else we do, the negotiations, the other things that are happening that affect children. I'll give you an example. If two communities are fighting out there, we have those conflicts, and children get affected, they have to sit down, and the clans have to discuss how they are going to stop the killings. There are children involved, that is an AJS mechanism. How do we take care of the rights, safeguard the welfare of the children in that place? We have a couple who are kila mtu ameamua kwenda kwao, wameacha watoto kwao. That's what I'm told Gen Z's do. Kwa sana unaenda kwa mama yako, jamaa anaenda kwa mama yake, watoto wanabaki kwao peke yao. What do we do about such situations when they go before the Jiko and she needs to refer them to something? I'm just saying that I agree we need to concentrate on the big elephant in the room. How do we, for children in conflict with the law? But I'm telling myself this is an opportunity I have to hold this gentleman accountable for those things I've been saying. They never thought about children when they were prepared, and he admitted. They did not consult the children when they were doing the diversion for animals, so the AJS policy. So where else? If you don't say that ikuwe hapo, nitapata wapi nafasi ingine? Where will I get another opportunity? Not me, Madeka, but as the committee for children issues, where else will I get the opportunity to get them to actually now go out there and consult children and ask them, when these discussions are going on for different AJS mechanisms, what is their role? How do they participate? How do they get their rights taken care of? Their welfare safeguarded when those discussions are going on? When Maslaha, which is one of the things we're talking about, how do we get the children on board? If you don't mention AJS somewhere, I'm just pleading that diversion imesha kubalika, but let's see where do we put the AJS, because we need to have children included in the conversation. We need to have children included in that conversation on AJS, and I was praying and hoping that we hold this gentleman here to account why they did not consult them. They can go and do it right now, tomorrow, or the day after. Come up with a policy for children. You want to defend yourself?
Yes.
Now
that my judge has mentioned me and asked, I think, look, I was not going to talk now because I am still restricted. But look, when a male is going for initiation in Ngoma, they leave the house as a boy, going to the river. It's expected that once they go to the river and they are part of the act, they become what? How about if you don't reach the river and come back? And what are you in the place between the river and a house. Are you a man or a boy? So in anthropology, there's a concept we call liminality, liminal period. Liminality. So one of the things my sister told me, yes, one of the things Nina has been taking into account, this is an assumption that an offender or suspected offender automatically belongs to the OTPP, which is not the case. There is a long path journey of justice at which they don't belong to the OTPP. Now, in that path of justice, what mechanisms can you use to realize justice for them? So it is very safe, therefore, to talk about AJS and diversion. Because you see, as I said later, but I'll give you the preamble now. You see, diversion, this is English, diversion, it is somebody with power who is directing, showing direction. But AJS is that the actor has agency. If you look at the act, it says that, for example, in the family session conferencing, the child can choose somebody to represent. That this constitution is about agency. It's a very libertarian constitution. So when you look at the journey of justice, you must ask, how about the space in the journey where the actor can exercise their most agency? I should knew that. That's one. Number two, Shakespeare asks, what is in a name? Now, the full name here. Multiple pathways for justice for children. Diversion pathways, framework, practice directions. Now, where does this fall in terms of the typology of frameworks to either offer a policy framework or to offer guidelines? So the other we take a language, and that's second part that fits. I think pathways framework may be ambiguous, and I would like to canvass that we either call them guidelines or practice directions. Because the policy chain, up there you have policy, then perhaps a statute, then perhaps guidelines, then perhaps standards, and so on. So if we have that logic in mind, then I think we don't talk about framework at this stage. Because framework is the grand direction that we have. Now here we want to have very operationalized level. So I would remove pathways and I would put diversion, either I would call it, not up there is okay, down here. Diversion, and then yes, I would call it either practice directions or guidelines. But the very doability is what we need at this point.
Yeah. Thank you, Doc. What I was trying to do, actually, as we were all talking, I remembered STAJ. And STAJ does talk about the multiple pathways of justice. And if we have multiple pathways of justice for adults, we can certainly have it for children. And I like the direction. Linda, does Linda have a microphone? I was going with the practice directions. Actually, I even found the law for it under the Children Act. So we can say section 29 of the Children Act does give the Chief Justice powers to develop rules, because the rules are for children in conflict with the law, by the way, and in the process of, I don't know if there's something in the 80s on this. That is all I know. So at least we have that. Now we need to differentiate between those and whatever it is that we are coming up with here. So that is why I think I like what Doc is saying and what Judge has also said.
Thank you so much. I think when we came to this conversation, and I think from the very
clearly on AJS. But that is reminding me the theme for our conference is integrating the formal and alternative justice systems for children, and essentially to enhance access to justice for children, right? So is that
Yes, I'm sure you
yes.
Why I came
That is showing me, yes.
Why I came here?
Yes.
Yeah, one of the reasons because he was here, and that is the issue that, and I think I said it in my opening remarks yesterday, that I'm holding them accountable, that they never spoke to children. So all I'm asking for Linda is for us to get permission from this group to let them go and talk to the children and come up with a policy. Or come back to us and ask the children what they want. If they want AJS anyway, they may not want it.
Great. So I think what I hear is, from what Judge is saying, and you can clarify that, this is the beginning of the process of, especially for AJS, because they've actually already talked to children. Yeah. But for AJS, we need to ask the children, what do you want? So this is the process of, this is the beginning of that process.
Yes.
It's not that we're going to now develop the document from today. It's the beginning of the process, and I think we can allow that process to begin. Do we have consensus? All in agreement say, you say yes or no? Aye. Okay, let's see. All in agreement say aye. Aye. All who do not agree say no. Nay. Please say it louder and with joy. You say, yeah, I mean, I respect that. So I think the ayes have it. Please let's clap for ourselves. But as you can see, ladies and gentlemen, this is half of what will be included in whatever else that we will come up with. Thank you very, very much for allowing me to facilitate this session. It's been quite a wonderful learning process, and I hope to see you again when we are looking at the document, whatever that document will be. Dr. Steve, the microphone is now yours.
We do those things before.
We do those things. Oh, we do the. All right, stand up and stretch as Judge is saying. Which one? Oh, yes, Marriott. Come and do for us that one that you were doing and people failed.
Oh, yes.
Please clap for me.
Thank you. Thank you so much, Juliet. So, nimefunzwa ni kufungua kwanza alafu tunafunga. Okay, so as I had showed you earlier, 1 is a clap, 2 is a snap, and 3 is a star. Sawa. So now, when you are in pairs, you alternate. When I do 1, you do 2, I do 3, you do 1. Okay? Okay. And we go on. So, ready? Yes. 1. No, you have to say it between yourselves. Because there is a time I will do 1 and there is a time Juliet will do 1. So 1, 2, 3. No, 3 is mine. 1, 3, 1.
Okay, higher.
1.
Okay.
We have improved. We can now sit down. We have slightly improved. Of course, that is easy when you are alone. But this is why we are here. We have to think together. Karibu sana, Chair.
Thank you very much. Habari za jioni. Mwanzo nimshukuru sana Judge kwa kuwa jirani yangu mwema leo. Nimefurahi sana kwa sababu amenifunza mengi. And really to the organizers of the meeting, 2 things. I know my sister has told me not to speak for long. It's okay. it is good to attend a meeting, but it is better to attend a meeting where you find good people. So I attended a meeting a long while where there were very good people. And I was telling Judge, I started human rights work for salary when I was age 26. And I used to attend meetings like this one, I would organize, and I would see people my age seated and I would ask, what are these old people doing here? So now I am in the group of the old, and it was such a pleasure to see how the young people did a very good job, and I thank you very much. The second point, before I make my few observations, is there is no problem in holding divergent opinion. So we should never worry about that, and it should not be a source of any polemic feelings. It is, in fact, very good that we do that, because if you look at this room, we all have clothes of different colors. Of course, if you were in Makueni, where Judge is, you would have had a fairly yellow and blue, yeah, you know, but it adds beauty, isn't it? So that should never worry us. Now, members, unfortunately, I'm a university teacher, so I would like to do a bit of what may sound like teaching. And now, when you see any provision in the Constitution or any text, you must ask yourself, what is the meaning of that text? This is a distinction between a thick description and a thin description. Many legal texts are thick descriptions, be it the Constitution, be it the statutes, even most guidelines are thinner, but constitutions and statutes are thick descriptions. So when you see diversion, the intention, the issue is not diversion, it is why diversion. So don't say it's diversion, no. The intention is why diversion. And if you go to the Constitution, for example, it's very clear, Article 59, this purposive way of thinking, which of course we use it for the Constitution, but it should permeate in our general logic. Now, I would like us to agree that what we're dealing with is a systems issue. And a system is a complex thing. It's a complex thing. And this is the distinction between a complex thing and a simple thing. A simple thing has what we call a term problem. A term problem is a linear issue. For example, we are here, we have paid for water, it has not come. It's a linear question. You just tell them, we paid for water for 40 people, you bought water for 30 people. Where is the remaining 10? They'll bring it. It's a linear question. There is one solution for it, not a term problem. But we are dealing with a wicked problem. The children issue is a wicked problem, as we saw, and I really thank those who did the role play. It was very, very good, very, very good. It was very good. The mothers were real mothers, and the other actors, so it was very good. And the children, of course, were actors. So you could see it's a wicked problem. This is from a different example of systems theory that I teach. But if you are to change these with the elements of what manifests itself when a child is in conflict with the law or in conflict with other societal norms, it's not always just conflict with the law, because that is very positivist thinking. No. In fact, many conflicts that children face every day that cause a lot of harm to them in terms of what corrective measures are done are conflict with their norms, societal norms, gender norms, religious norms, cultural norms, you get it. So you will see a very complex array. So you can't resolve it using a singular direction action. Now, that brings me to where we are. Well, the problem we have now, and I have here three kinds of diagrams. We are largely here. We agree we are multiple actors. But we tend to work too randomly in our own sites, and I saw in the meeting at some point a lot of attention to protect our own little cocoons. We, so and so, we do this. So this is where we are. But our interest is to deal with children's justice. Now, In organizing this conference, there's a movement towards here in terms of creating a relay system. That is why you see this conference is organized by more than one person. What Juliet was helping us to do is to move a bit more here and see. What is it? To have a bit of functional way of organizing ourselves. So she asked, what is the question? Who will do it? What is your role? So we will end up with the leadership of Justice Aleka organizing ourselves into little functional groups that have got intercommunication. So our central point is the standing committee, but they can delegate certain part of the work to, let's say, nurse engineers. They can delegate to some of the councils. They can delegate to the psychologists. Then we bring it back to them. But this functional mode is the one that we really need to embrace when we live here. But ultimately, the ultimate goal is to have this kind of system where we work fairly independently, but with what we call in proper English a congruent way of communicating, or a congruent way that creates what we call intelligibility. When I say it from where I am, she understands it. When you say it from where you are, I understand it. This is, intelligibility. Those of you who confess religion and so on, you know the problem of Tower of Babel. So we don't want to. Tower of Babel problem is this problem of. So this is where we are moving, but now we are living here. This is where we are. So don't destroy this one by going back here or even worse off here. Let's remain here now in terms of trying to do a bit of good division of labor. Those of you again who, unfortunately, I have to give examples from the Bible because it's a book I read more often. Apostle Paul talks about the body, the church as a body, and see the hand has a role, it communicates the head. You see, I injured my feet. Now I can't walk in the speed I normally walk at. And many other appointments of mine are collapsing because I can't do multiple presences, So this is where we're moving to. Finally, there are some few quotes that I would like to raise. One, if solutions can't be found within a system, if it's impossible to find them, then you must change the system. So let us not be too bought in. I wanted to call out Linda again. I can't see her anymore. Is she here? Okay. The retired Constitution had Chapter 5, which now we have as Chapter 4, which had the so-called Bill of Rights. But did you know that exceptions in Chapter 5 were more than the provisions? The language I had from ODPP was more of exceptions than provisions. It's not possible, can't do. Then there's a problem. That kind of a system has a problem. If the exceptions are more than the provisions, is a problem. So that if the system can't work, do away with it. Then, Justice Madeka said, the call for all of us is to be able to play our place as active actors in crafting something that advances child justice. So forget about our interests, but what we are invited to is what are you contributing to in crafting something for child justice? And then my sister Ijemima said, we need to have systems and structures such that if a child is diverted, this child will be connected to another subsystem of systems. So when a child is diverted, they don't find themselves alone or in a limbo or in liminality. A child is diverted, there's a place that can hold them. And that shows we have to work as a system because I can't do everything. So with a diverted child, a psychologist is at hand. With a diverted child, an elder is at hand. A counsel is at hand. A teacher. So this is a real relay. We can't perform it in this framework of terrains and monopoly of power. It needs a flat pyramid in terms of power. It can't be the sharp pyramid. So our intention is, for mimi, nataka mtoto akiwa diverted, akionyeshwa njia mbadala, kuwe na mtu atamshika mkono, kwenye ile nafasi ambayo anaambiwa achukue. So that should be the interest. And that way, we'll have a formula of having this, what I'm calling polycentric governance. Polycentric governance works when you have that as a logic, not the one of creating content. And finally, not finally, I just put this when Juliet was speaking. Let's always have this policy logic in mind whenever we want to have interventions. So where are we? Do you have a policy that provides for diversion for 80 years? Yes, we do, isn't it? We have explicit policy statements. Do we want to have statutes? That's a discussion we need to have. But we, in 80 years, we decided we don't want a statute. Why? We fear that if you are, imagine the current parliament, or even the Senate, or this will have to go to the National Assembly. Imagine that National Assembly. If you take to them something that talks about elders, what will happen? There is something about their grandfathers. For them, elders are men. And for us, elders are not men. Elders for us is a category of honor. Remember, in a scale, we are Radio Uganda Surabaya, naimwa shilingi ya ua tena maua. Anasema hebu tupa shilingi pale, hata kijana wa miaka 25 hata nini? So sisi tunasema hebu kuwa mtu wa haki, hebu kuwa mtu wa ukweli, hebu kuwa mtu wa kuendeleza haki za binadamu. Tunaitwa nini? Mzee. So mzee is not age, it's not gender, it is a value system that you can tell. That's the idea of mzee in our constitution. That's the idea of mzee. But the people in the National Assembly do not understand that. So we are giving them time. We'll reach them one day, but not now. And our parliament will change. One day, our parliament with about 200 Babu winners. It will come in your lifetime, I can tell you. I never knew that the day when, for example, do you know even children's discussions? When Clan was a major institution, running children conversation, even when Kaido was there, you would never go to a conference that we have now, where over 80% of participants leading the conversation are women. Never happened. Never happened. FRIDA was the only organization which could convene human rights meeting and there were many women. I was at Kenya Human Rights Commission. It took us time to go and learn from FRIDA. How do we demasculinize human rights? At that time, they didn't even need to see FRIDA as a human rights organization. So we've come a long way, but look at where we are. Just 20 years later. 20 years later. So we have to move there. So now, standards and practice directions, which is where I think we are now, here, on this kind of matter. So always think the logic, and KIPRA has developed a policy framework for Kenya, which we are all asked to think through. And this is a summary from that KIPRA model, which guides all of us, because we are one country, we are one legal logic. Finally, why are we doing this? We are doing this for access to justice. That is it. We had a meeting with Justice Ngugi, and I've been one of the most privileged human beings. When I got my doctorate, I met Justice Madeka, and together Justice Madeka. During those days, by the way, during 80 years, it was never fashionable. We had no money. I'm not saying we have money now. As an individual, they are recording, I can't disclose because KRA can get access. But Justice Madeka was in the first phase of the task force with Justice Ngugi, and we really worked for this country. We are hoping that one day when heroes, and hero will be accorded based on performance and true patriotism, we will not miss our place. But the first thing we did, and this is my last slide, my sister, the naming. You know, it's a real shame. It's a real shame what to see in this country. Professor P.L.O. was here. He asked a question. Do we have a statute named Boston?
Yes.
We have.
Yes.
Where is Boston?
Somewhere
in the UK. Now, if it has been baptized as somebody, we have naturalized it. We have baptized a system 80 years, and you ask us where is it coming from. Sure, what question is that? Multiple law justice. Have you heard of that concept?
Yes.
Don't people use it in a way that's acceptable?
Yes.
Do you know who crafted the word? Professor at the University of Harvard. Now, the name AJS, now you should know of your records was crafted by Justice Mutunga, myself, and Justice Nguni. And then I'm also there. In fact, my most enjoyable years as a family man was when I was a house husband. For 2 years, I was a house husband. So I would wake up in the morning, I'll stay at home. My wife would go to work, and I would ask her, please, I know I'm not airtime. She would give me 500, and I tell her, this car I'm going to use has no fuel. She put 1,000. The only problem in the evening when she comes back and the gate has put down and they ask, where did you go? And I would expect that was difficult to answer. But in the most enjoyable years, I want to go back after some time to just move houses. It's a very good thing. Having no power is sweet. So this nonsense that head of household is a man, of course, is completely nonsensical, stupid fiction. I teach economics as well. And when I teach economics, when students want to go and do research, I ask them, who will you interview? The head of household. You fail with your baby. Exactly. Okay? If you tell me the adult in the household, it's okay. But the head of household, who is that? How will you know the person? How does the head know that? Who brought that nonsense here? The Europeans, based on Victorian what? Tradition. Now, here, while we are calling this alternative, it's not based on a tradition of subordination. It is because we have said in Article 159(1) that judicial authority, and Nina should have been here because judicial is not judiciary. Judicial does not mean what? Judiciary. Judicial is that power to adjudicate, that power to promulgate, that power to intervene, to create the idea of coexistence. And that belongs to who? The people. Then the people do what? They donate. Just like the dispatching authority belongs to who? To the people. They donate. Executive authority belongs to who? To the people. They donate. So even ODPP, then kwanza hivi tumetoa tu kidogo. Because when nasema ule tumetoa mkubwa ni kuti na tribunals. Alafu DPP alikuwa appointed kuwa a performer officer wa hiyo institution. Unaona? Sasa once umeamua umedonate wapi? Haya namaliza. Umedonate wapi? Mahali umedonate lazima uheshimu. It becomes the center. That is why we are calling it alternative. Because we have created a center. Ungeniuliza, and that's the logic you see in Article 60 when it talks about land. The three types of land as in a hierarchy: community land, private land, public land. Ungeniuliza, the best name should be multiple justice systems. That should be the best name. But that lacks the logic of convergence. That's why we call it alternative. Finally, why do we call it justice system? You have to look at the article purposively. What does 159(2)(c) want to do? And you remember when Mheshimiwa was presenting, she highlighted in yellow about technicalities, justice shall not be denied, shall not be delayed. The purpose of that article is to execute Article 48. That article is not to tell you 48 on access to justice. No, it's not about to tell you at when you have a case go here. No, it's telling you this is how you achieve Article 48. That is the intention of 159. 48. So that's why we call it justice. Then it is also about a different logic. We call it system because it says there are many worlds of justice. Many worlds of justice. That's why we call it system. So sio ADR. ADR ni subset ni mbinu ya kutumia. Ni mbinu. ADS sio mbinu. ADS ni hali ya kufanya, ya kupata haki, ya kuishi. Na inaanza unapozaliwa mpaka unapokufa. Ndio ADS. Sasa unaona hapo basi tunasema iangalie katika niaba miwili kuna grievance na kuna remedy. Hapa ni sehemu ambazo una intervene na hapo ni zile capacities zinazohitajika. So kwanza recognition. Tatu ukiangalia pale inasema After, look at the logic. Our constitution is written very political. And I was privileged to be in Bomas. I was delegate number 365. And I was in Naivasha when the committee of experts were meeting as a secretary. And our constitution is written like a good piece of Lingala music. It has got a rhythm. The Mohesh said, kwa nini umeweza version? It has what? A rhythm. Hii ni Lingala. Rumba. So hiyo rumba inaanza na recognize. Alafu wajue. Alafu waclaim. Alafu wadjudicate. Alafu enforce. Our Katiba has logic. And this is the logic. Everything inaanza na recognize. Alafu mjue. Alafu mkishajua nyinyi mna nguvu ya kuclaim. Alafu mnaambia nyinyi hakikisheni mmepata adjudicate. Wanasema there is no word in Kikamba or English that fits it. It's in that word should interpret. Tegigi. I really want to thank all of you for this session. As you can tell, I've really enjoyed it. I hardly sit in conferences for 2 days. So to have sat here for 2 days was because you are my best teachers. And I thank you very much. It's now my duty, simply a honor and pleasure, to invite Justice Madeka to give us her closing remarks. Asanteni sana. Karibu.
Usivunje mkutu, acha nikushikilie tu. Unajua nani Efi? Akivunja hiyo mguu ingine, ile kesi utapata hutawezana naye.
So, thank you, Daktari. It's always a pleasure talking to Daktari, working with the Daktari, doing things haki or justice with Daktari. And I know I've been asked to come and help close. I hate that word of declaring something close. Mimi sitaki kusema hivyo. I want to remind us that we came here so that we can discuss both the formal and alternative justice systems to strengthen child justice in Kenya. As the standing committee, we consider ourselves the actors, a chain. There's a ritual I do, and I'm going to request you, if you don't mind, si ritual ile ya riswa, ni ritual ya watoto. It's a ritual that comes from looking for peace among ourselves. And to do the ritual, I will ask us to stand. And then you hold hands in such a way that we have a circle. So let me come there. So, I don't know, just hold it in such a way that we have a circle. So hold the hand of the person nearest to you. You need to have a circle. But you can hear me. Lakini ushike circle, ukishika ushike circle. Ushika hiyo tuone. So this ritual, it's just to demonstrate for ourselves that if there was prison, there's no child below 18 here, but if there was, we would have asked them to just sit here, so that we'll be able to tell them what we are going to say. It is to just demonstrate the chain, child justice chain for us. Because why did we come? So we don't know what to about haki. And then if you drop, if this child is in and you drop, and you are one of the persons who is giving a service, the child will fall through. And one of the things we discovered as a task force those days, when we were doing the task force work, was that children fell through the cracks many, many times because each of us was acting by ourselves. Judicially, mtoto ni wangu. Akienda kwa children ni wao. Akienda kwa probation ni wao. Polisi wakishika ni wao. Wakishtakiwa DPP ni wao. You know? But we accepted at some point that mtoto ni wetu. Kijiji huko nyumbani ilianguka somehow. Si ndio daktari, we are trying to raise it. But we agreed that we are going to be that village that we say raises children. So when we have the justice system, why are we the child justice system? Because we have an obligation. Constitutional, we have been told. Kama mnaamini Mungu is also coming from God. Kwa
sababu mtoto umejua kuna mambo kadha wa kadha ambayo hawezi. Sisi tumepatiwa hiyo nguvu ya kisheria na nguvu ya kuwa sisi ndio watu wazima in the room. So this is something that I like us to do, and something we'll recite. Someone said do it that yesterday, we do it together. And then after that, I'll say what I need to say. So this is what we say. We said it. Kwamba haki ya mtoto ni jukumu letu sote pamoja na mtoto. Can we say that? Haki ya mtoto ni jukumu letu sote pamoja na mtoto. So from today henceforth, if you forget anything else we did today, remember the diversion toolkit we are going to improve ni haki ya mtoto pamoja na haki ya mtoto pamoja na sisi na yeye pamoja na yeye we are doing it together. The JAJS system, if it ever comes out for children, it will also be for the children with the children. Now finally, I want to say this, that I will not declare this as closed. I will declare that ile kazi tumesema ianze. Tuko pamoja? Tumekubali? Na tupigie makofi. Asanteni sana, na kama inawezekana tuimbe national anthem alafu tuende nyumbani. Naweza imba nani mtu wa kwaya? Akuje hapa. Hapa mtu wa kwaya. Nasikia ndio mtu wa kwaya. Nenda uanzishe tuimbe national anthem na Kiswahili basi moja. Alafu that is the closing prayer I can offer.
Thank you so much. Najua mimi ni mwisbiera, mnasema kwa Okay, let's all, I think we all went to, what classes are those? Girl Guides, Scouts, and yes.
Na Kiswahili.
Na group of schools. Okay. Mungu yetu, ilete baraka kwetu. Haki iwe ngao na mlinzi, na tukae na undugu, amani na uhuru, raha tupate na ustawi. Amen. Thank you. I would test you guys and have you sing stanza 2 and 3 for a prize. But I know you will flop terribly. You want to try? Glory stanza 3. Kenya istahili heshima, tuungane mikono pamoja kazini, kila siku tuwe na shukrani. Tujenge taifa letu, ndio wajibu wetu. Kenya istahili heshima, tuungane mikono pamoja kazini. You think, how do you think? Mko sawa, lakini kuna vile we need to do better. Thank you so much. I do not have anything else to say. Thank you, Judge, for officially closing the event for us. Can we give her a hearty clap? And a clap for ourselves for being attentive students for 2 days. Asanteni sana. As we come to the close of this conference, I rise not on my own behalf, but on behalf of TDH and our country director, Mr. Craig Tucker, to thank all of you. And we have deep appreciation for each and every one of you who made it possible to convene, everyone who came, everyone who supported us in their various capacities. And special thanks to the children who joined us yesterday, Karen, Livingstone, and Angel, who made their voices heard in strong terms. And if you are here, you understand what that was. They came out very strongly and challenged us to do our jobs and do it right. And we hope as we have taken that pledge, we will do our jobs and do them right moving forward. Our partners in the government, the judiciary, DCS, now it's the State Department on Children Welfare Services, and the various civil society organizations, we extend our heartfelt gratitude. UNICEF, particularly Eri Mathers and Roslyn, who have held our hand and supported us even financially with this event. NACI, AJS, Dr. Akoth, Professor Ngugi in absentia, and Jemima, who have been very key partners in organizing this event. LRF, Mr. Isao Riaro, if you went to schools, some schools I went to, it's Iso Riaro, and Mildred Arum, thank you so much for helping us from conceptualization. The NCAJ Standing Committee on Children Matters, Juliet, ubarikiwe sana. You know, she told me on call, you came and you didn't find me. I'm the first person you should have called. And you know what? She was right. Because I was just fumbling and, but she really came through. FIDA Kenya, Haki Jamii, and CMR Africa, together with the police service, we thank you for participating, for showing up, for making your voices heard on behalf of various other civil society organizations. Honorable Justice Teresia Matheka, you've provided a battalion for us, and I mean it, a battalion. She was like, what do you want us to do? And when I say NCAJ, I want you guys to do this, I got a whole army. I was like, guys, please, you only have 6 slots. I got 11. But financial constraints, of course, we couldn't accommodate everybody. But we thank you so much for the support. You gave me Mariel, hi Mariel, who was running around. I don't think she sat for the conference. She was running around helping with the meals, helping with everything out here. Thank you so much. Our colleagues from TDH, Joyce and Joy, thank you so much, together with our country director in absentia, who believed in the vision and supported it wholeheartedly. One day I will tell the story of how this event was planned and how I considered myself a baby in this space, and everyone was very supportive. I did not once get someone turn their backs on me and say, hey, sasa nini. Of course, there was that TDH Kenya, TDH Netherlands, who are you? But still, when I explained the concept, they were like, okay, this is something we can get on board. So thank you so much for your support and for holding this vision and owning it. At this point, this is not a TDH event. All these banners that are here, this is all our event. Mtoto News, I do not have words. I really appreciate your work, all that you do, empowering children to be able to speak up. You've seen how they performed, right? Yes, and we hope to continue with that. And for everything that went well, we have all of us to thank for. And for whatever did not go right yesterday and today, we apologize. Please extend some grace. It was the first time. And you can give your feedback, and we can definitely do better next time. And it is my prayer that when history is being read, may you be remembered fondly for standing with children who are the most vulnerable in our communities. And with that, thank you so much, and may God bless you. Najua mlikuwa mnangoja announcement. Kuna chai. Kuna chai, guys.